Here we have the Sixth Amendment to the Bill of Rights in the Constitution. And if I could sum all these up, it really talks about rights of the accused. Okay, when you are accused of something and it might be correct or it might be false, what kind of rights do you have when you're accused of breaking the law? So what happened was that in medieval times in England, like many countries, there were a lot of abuses in this regard. Because if you accuse someone under the law, then they have to defend themselves. And even if they're found innocent, it's going to be a long and hard process. And in some cases, you can detain them or, ruin their reputation. And so to get away from these types of abuses and bad practices, our founding fathers put things in the Bill of Rights about how accused people have certain rights. Okay? So we're going to take a look at those. So first off, you have the right to a speedy and public trial. Now, what does speedy mean? Well, they didn't say. So as fast as the judiciary can bring it to trial, that's what you should have. And that's how the Supreme Court is ruled. And so in today's day and age, a speedy trial could take 6 to 9 months before you're even brought to trial. That's not very speedy, okay? And so, what's that a problem with, or what's that a function of? Do we have too small of a court system that doesn't process people, fast enough? Do we need to spend more money on the courts? Do we need to stop passing laws that make so many things a crime? Do we need to stop committing crimes? Those are all of the questions that we would have around this in the debate about, a speedy trial. But the Supreme Court has said that if the judiciary is moving as fast as it can, then that constitutes a speedy trial. However, you might say it's not very speedy, so that's a debate we need to have in our political situation there. The next part is that it has to be a public trial, okay? And so what would happen in the Middle Ages is that people would be accused and they'd be pulled in and everyone was told, well, we had a trial and they were found guilty and we executed them the next day. And everyone goes, well, what happened? We don't know. And so if you have private or secret trials, then any number of abuses can go on. Was it a correct process? Was it a fair process? If it's not public, we don't know. So trials under the Constitution have to be public. They have to be allowed to be seen by everyone so that you can see what the judges are doing. Are they applying the law correctly, fairly, or not? That needs to be seen, and so by making things public, that allows the people to be, responsible for what's going on, because the government is supposed to be we the people, and so they have a right to know, and they also have a responsibility to take up that trial and see whether it's being applied fairly or not. Okay? The next one there, you have a right to an impartial jury in the district where the crime was committed. Okay? So there's a couple things there. First off, you have the right to an impartial jury. Well, I'm not sure that it's possible for any human to be impartial, okay? The way they try and do that today is you select a large pool of people, and so I'll get a notice all the time that I'm on the jury pool, and I show up there and they will take 24 people, depends on the state, and they will start paring them down to the 12. So each lawyer for the defense and for the prosecution, they each get to exclude 6 of the 24 jurors there. So they ask you a bunch of questions about your viewpoints, and then they exclude 6 each, so 12 are gone, and then 12 are left, and that's your jury, okay? So is it perfectly impartial? No, but at least each lawyer gets a chance to decide and how, the makeup of that jury is going to look, and they're left with the 12 people that they say, well, that's as close as we can get. All right? So that's how we approach this idea today of the right to an impartial jury. We try and select people that are as close to impartial as we can, you know? And so that's how the Supreme Court has ruled on that the process of doing it that way gets us, pretty close, and we have to call it good. Okay? The next one there, in the district where the crime was committed. So the understanding of the Founding Fathers was that America was a big country. At the time, it was only 13 colonies and, not very big population compared to today. Today, we have a vast, large country. It is one of the biggest in the world geographically. It is one of the biggest in the world in population. I think we're third in the world in population as far as countries go. And so you will have amazingly different cultures. So there will be different cultures and ideas across the United States. We see different variations just in the state of Oregon, between the west side and the east side in Oregon. And surely things here are going to be different than West Virginia, or Florida, or Michigan, or California, or Texas. And so what our Founding Fathers did to solve this problem of cultural differences about what was an acceptable crime and what was not acceptable, how did they write those laws? They said, well, let's just have the trial in the place where the crime was accused to have been committed, okay? So if there is a crime in Oregon, then the trial is in Oregon, okay? And then the jury you select are from those people, and they get to, in their way, define how their culture and ideals actually adjudicate these type of crimes. Because in some parts of the country, drug usage is a crime, and in other states drug usage is not a crime, and those are very different ideals and different cultural values about how to approach the use of drugs. Some states just say, sure, whatever. Other states say it's absolutely forbidden. Which way are you going to go there? That depends on the local culture. So that's how our Founding Fathers solved this problem, is put it in the hands of the people in the area where it is said to be a crime, and let them decide. Okay? The next one there. Right to be informed about an accusation. So this is pretty much everywhere in America. We don't worry about this so much, but it was more of during the medieval times that people would be held, they would be accused of crime, and you'd say, what crime did I commit? And they would just say, we'll figure it out later. And you're just left in jail at the whims of a king or a prince or some government during the medieval time period there. And what was your crime? You couldn't know because they wouldn't tell you. You couldn't mount a defense because you weren't informed of the accusation against you. So we always inform in America. That's a pretty straightforward one. And the Supreme Court has always ruled on that. You need to tell the person what crime they're accused of. Right? You have the right to confront witnesses against you. So another practice in medieval times was that they would say, oh, someone accused you of this. And you say, well, who is that? And they go, oh, it was a person. We don't need to say who it was, but you're accused of this. And they'd say, well, I didn't do that. Who was the witness? And they would say, oh, don't worry about it. We just have an accusation. And so it didn't lend itself to very many fair trials in that case. And so our Founding Fathers said, you have the right to confront the witnesses against you. They have to come out in a public trial and say, I saw this person do that, or I witnessed this event happen. And so therefore the person can then say, okay, look, but, is this what you saw? Is this how it happened? That you get to confront or question the witnesses against you. So we don't just take whatever people say as truth, because false accusations could certainly be leveled for all sorts of bad reasons, or even just mistaken reasons, like they thought they saw something, but they really saw something else. And so in order to get to the truth in that trial, You have to be able to confront the witnesses against you. All right? You have the right to subpoena witnesses in your defense. Now, a subpoena means that you can deliver a letter to them and say, you must appear in court to testify about what you saw. Okay? A classic example of this would be if you are driving down the street and you have a green light and someone else runs the red light and hits you, they're at fault for running the red light. And so you go and say to someone, hey, you were waiting at the light. What did you see happen? And they say, well, that person ran the red light and they hit you. And you take their name down. You say, okay, if this goes to court, I'm going to send you a subpoena that says, hey, could you come testify on my behalf that I had the green light and they had the red light? And the person will say, yeah, And in fact, they really can't say no, because they can be subpoenaed to be a witness in your defense. And so the court will give them an order. It says you must appear at this time in this place and testify to what you saw. Okay? And businesses must let you off of work for that. Okay? You cannot be fired for doing that. So that's part of the law. So people must appear in court if they are subpoenaed, and they must testify to what they saw. Okay? So yeah, you want that person to be there for you, because if someone hits you running a red light, and then they say, no, you ran the red light, you hit me, then you definitely want a witness in your defense. See, you want to be able to subpoena and make sure that person comes and is a witness. All right? So, again, these are, rights of the accused, and our founding fathers were really trying to help the justice system get to the truth of the matter. And so that's why they want to allow a subpoena for witnesses in your defense. Last one here, you have the right to an attorney. Okay? And we'll talk about that more. What does it mean by the right to something? Because this is an interesting interpretation that has ramifications beyond just this one. But for this one here, what our founding fathers meant is that you have the right to an attorney. They meant you have the right to bring an attorney with you to court. Okay? But what happened is that they saw such a huge discrepancy between people who tried to defend themselves and people who had an attorney, that it just seemed like a night and day difference. And so what happened was, anyone with the money to get an attorney had much different results than the people who appeared in court and tried to defend themselves. Partially because they didn't know what they were doing, partially because the laws have become too complicated, and so that's another issue we got to address. If it's too complicated for a common person to defend themselves in their own country's courts, what has happened to the law there? Okay? So, because we have that discrepancy between those who have attorneys and those who don't, the Supreme Court ruled that if you do not have an attorney, the government will actually pay for you to have an attorney. So if you hear that in the Miranda rights, you'll hear that on TV all the time. You're under arrest for this. You have the right to remain silent. Anything you say will be used against you in the court of law. You have the right to an attorney. If you cannot afford one will be provided for you. Do you understand these rights as I have read them to you at this time? Okay, the officer, if they're arresting you, will actually have the card because they want to read it exactly, and they will read it to you. And you say, well, I don't understand English. And they will get a translator on the radio, and they will translate that Miranda message to you because they want you to know your right. You have the right to remain silent, and you have the right to an attorney. If you cannot afford one will be provided by the state. So instead of right to bring an attorney, which is what was the original meaning here, what the Supreme Court has said is that you must be provided an attorney. So your right to an attorney means you always get one. Okay? All right. So you got to understand, though, are you getting the most amazing lawyer ever? Probably not. Okay? These are usually entry-level jobs, people that are straight out of law school that are working and making money with, as a court-appointed attorney. They usually have a high caseload. They usually have a lot of work to do. And they're looking to move up in the world to a private practice. So, is it still the level playing field that we would desire? No, it's probably still different, but at least it's not the huge difference that we were starting to see. Okay? So that's the sort of philosophy or framework that the Supreme Court has come up with in regards to having a court-appointed attorney. All right? So these are questions that we have for the Bill of Rights about the rights of the accused, and these are hopefully the answers that the Founding Fathers have provided. All right? So if you have any other questions, we'll talk about some of those, because this is an area that is ever evolving, dealing with things such as COVID. Do you have a speedy trial if there's COVID? Do you have a speedy trial? Can you speed it up with technology? How does technology work for these things? Can you have online Zoom courtrooms? It's a really fast changing area of the law, and these things are going to have to be sort of sought out and addressed in each of their components and understood. Okay? So you're probably going to see a lot more Supreme Court cases on these areas here as they're adjusted for the changing of times. All right. See you in class.